The critical question of whether a statement made in a moment of distress can be admitted as evidence often hinges on its spontaneity and the speaker's state of mind at the time. In the case of the state of Tennessee versus James Dellinger and Gary Sutton, heard in the Blount County Circuit Court, Judge D. Kelly Thomas Jr. presided over a motion hearing on June 5, 1996, to determine just that, specifically concerning statements made by a man named Tommy Griffin. What were the attorneys, Mike Flynn and Edward P. Bailey, Jr., for the state, and Eugene Dixon, Charles Dees, F.D. Gibson III, and John Gergen for the defense, trying to establish about this key piece of evidence?
Finn, the core issue was whether Tommy Griffin's declarations to Officer Drew Roberts could be admitted under what's called the excited utterance exception to the hearsay rule. That's specifically Rule 8032. For a statement to qualify as an excited utterance, it generally needs to be made spontaneously while the person is still under the stress of a startling event, without time to reflect or fabricate.
So it's about capturing that raw, unadulterated reaction. Officer Drew Roberts, an Alcoa police officer, was called to testify. What exactly did he recount about finding Tommy Griffin?
Officer Roberts testified he was on duty on February 21, 1992, and responded to a call for a possible fight. When he arrived at the Hunt Road area near Mills Street, he found a Ford Ranger pickup truck. Two men he described as being in their mid-50s were standing beside the truck, and Tommy Griffin was sitting in the bed.
And what was Griffin's physical state when Roberts first saw him?
Roberts described Griffin as partially clothed, wearing blue jeans and tennis shoes, but no shirt. He had scratches on his upper body and a cut behind his left ear. This appearance, Roberts noted, was consistent with someone who had been in a fight. He also detected the smell of alcohol coming from Griffin.
Before speaking to Griffin, Roberts interacted with the two other men. What did they tell him, and was there any objection to that testimony?
Yes, they told Roberts they were going up Mill Street to eat when they observed Mr. Griffin crawling around in the grass. They had then helped him into the truck bed. The defense, particularly Mr. Dees and Mr. Gibson, objected to this as inadmissible hearsay. Judge Thomas, however, allowed the testimony during this motion hearing, explaining he needed to hear it to decide what would ultimately be admitted to a jury.
Once Roberts turned his attention to Griffin, what did Griffin initially say about what happened?
Griffin identified himself as Tommy Griffin from Sevier County. When asked what happened, he said he'd been in an argument with some friends. Roberts asked who these friends were, and Griffin replied, "Just friends." When asked where they were, Griffin said, "I don't know." He then stated he got put out of the car.
How did Roberts describe Griffin's demeanor during this initial questioning?
Roberts testified Griffin's voice was shaky and scared, his lip quivering. He wasn't looking directly at Roberts, instead looking around as if searching for someone. Roberts said when he asked what happened, Griffin would say, "I just can't tell you, man." And his lip would start quivering as if he was about to cry. Then he would stop talking.
That sounds like a man in distress, but Roberts ultimately arrested him for public intoxication, despite also stating Griffin wasn't drunk. How do you reconcile that?
It's a crucial point. Roberts explained he charged Griffin with public intoxication because it was about the only thing he could do to get him off the street and to a warm place, given it was February and Griffin was without a shirt. He said he had no other choice because he couldn't take him home or to the police station without knowing who his relatives were. Roberts explicitly stated that Griffin was not drunk, but he was very coherent, well aware of what was happening around him, and not confused or belligerent.
So the officer's own testimony suggests Griffin was coherent and aware, even though Roberts interpreted his emotional state as scared. This seems to create a tension with the idea of an excited utterance, which usually implies less capacity for coherent thought due to the shock of an event. Did the defense attorneys pick up on this?
They certainly did. Mr. Dees, representing James Dellinger, cross-examined Roberts extensively. He pressed Roberts on the inconsistencies. He pointed out that Roberts' contemporaneous police report, Exhibit Number 1, didn't mention Griffin being scared or excited. Roberts confirmed this was true.
And what about the scared versus excited distinction itself?
Dees directly challenged Roberts, asking if he would describe Griffin as excited. Roberts initially said he was scared. When Deese reminded him of a prior phone conversation where Roberts had said Griffin was not excited, Roberts responded, "I believe my comment to you was that he was scared. Scared is a form of excitement." But Deese then specifically asked, "But did I not ask you if he seemed excited to you and you said no?" Roberts confirmed, "And I said no, but he appeared to be scared."
That's a significant distinction, especially for a legal standard like excited utterance. Did Roberts' account of Griffin's story about his friends remain consistent?
Not entirely. Deese brought up Roberts' testimony from a prior murder trial. In that testimony, Roberts recalled Griffin saying, quote, "They wasn't my friends. He said, I don't know them," end quote. This contradicted Griffin's initial statement to Roberts at the scene that they were just friends. Roberts confirmed this discrepancy in his prior testimony.
The defense also highlighted that Roberts never obtained identifying information for the two men in the pickup truck or the supposed friends Griffin was with. What was Roberts' explanation for this apparent oversight?
Roberts admitted that at the time, the thought never occurred to me to get their names. He said he didn't even consider that these might be the friends Griffin was referring to. He acknowledged that if he had a reasonable alternative to arresting Griffin for public intoxication, he probably wouldn't have taken him to jail, reinforcing his primary motivation was Griffin's safety due to the cold and his lack of shirt.
So the defense appears to be building a case that Griffin's statements weren't entirely spontaneous or unreflective, and Roberts' own memory or interpretation of events has shifted. Was there more testimony to reinforce this?
Yes, attorney Charles Deese took the stand himself to testify about his phone conversation with Officer Roberts on May 14, 1996. Deese stated he explicitly asked Roberts repeatedly, at least 3 times, whether Griffin was excited. Roberts, according to Deese, told me that Tommy Griffin was not excited when he was talking to him. Deese said Roberts indicated Griffin seemed more scared than anything, but explicitly stated at no time was he excited or spoke in a rapid fashion or hyperventilated. He said that he was calm.
That's a direct contradiction of Roberts' in-court testimony that scared is a form of excitement. Did Deese also address the evolving story about Griffin's friends?
He did. Des testified Roberts told him that Griffin kind of talked in circles. Furthermore, Roberts had told Deese that Griffin gave several different accounts of who the people were. First, he said they were friends, then they weren't good friends, then they weren't friends at all, and then that Tommy Griffin said that he just didn't know them.
This testimony from Deese really undercuts the argument for an excited utterance. The conflicting descriptions of Griffin's demeanor, from scared but coherent to not excited and calm and talking in circles, along with the inconsistent accounts of his friends, make it incredibly difficult to argue that these statements were made without any reflective capacity. It shows the subjective nature of interpreting human emotion and memory, especially when applying rigid legal standards.
Precisely. For an excited utterance exception to apply, the statement must truly be a spontaneous outflow dominated by the emotion of the startling event, leaving no time or capacity for conscious reflection or misrepresentation. The defense successfully introduced enough doubt about Griffin's true state and the consistency of his account to challenge the admissibility of those statements.
Understanding these subtle distinctions in witness testimony is critical to judicial decisions. Please share this episode with anyone interested in the intricacies of legal evidence.